Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are now going to discuss a Supreme Court judgment regarding the dismissal of a directly recruited judge presently working as ADJ. She was dismissed summarily. Why? Because she has altered a judgment. Actually, she has given a judgment in a case of 302, awarding sentence for 5 years, but after the application of the prosecutor, she has modified the sentence. She has altered the section to 304 part 1, that is culpable homicide not amounting to murder. So this is the essence of the case. Can you expect a district judge, that too a directly recruited district judge, do like this? It's done. The reasons we do not know. Right, the matter came up to the level of the Supreme Court. 3 judges bench. Honorable Justice Uday Umesh Lalit, who is going to the CJI in the next month, Ravindra Bhatt and Sudhanshu Dhulia. They held that it is correct to dismiss the sessions judge for altering the sentence in a murder case because the session judge has no judicial review power in CRPC, right? So she has approached the High Court. Ultimately, she came to the Supreme Court. While dismissing the writ petition filed by ADJ, you can read the case as Leena Dixit versus Registrar General, Madhya Pradesh High Court on 11/7/2022, that is yesterday. These 3 judges ultimately, in a cajoling way, they stated that we have got all sympathies for you. We wish you luck for your future endeavors. Of course, not in this department. Right. So, actually, she was on probation. You all know what is probation. Probation means during the period of probation, your movements will be watched, and if you do any mistake, without giving any notice, you can be straight away sent home. That is the greatness of probation. Maybe for a period of 1 year or so it will be there. Even for any person, for any government employee, whoever joins the service, he will be kept under probation. Right? During the probation, she has awarded 5-year sentence in a murder case under section 302 of the Indian Penal Code. But later, she has altered the section under 304 part 1, that is culpable homicide not amounting to murder. So, citing this irregularity, the disciplinary committee, 3-member committee, recommended for her dismissal. Even the High Court also agreed for the same, and she was summarily dismissed. Actually, as per the recommendation of the High Court, the state government accepted and she was summarily dismissed. Right? Actually, since the matter came to the Supreme Court, Honorable Justice U. Lalit, on seeing the modification, he says it's quite shocking. As a probationer, you cannot do like that. Administrative committee took a decision, so this court, that is Supreme Court, normally it doesn't want to interfere. In this connection, Leena Dixit, who appeared in person, she said that the principles of natural justice were not followed. That means she was not given any notice, and she also requests that a single mistake cannot be a ground for termination. Why? She has also said that this was my first posting, Your Honor. I am still learning. So actually, it was only one mistake I have committed, for which I was fired. So please remember, even I was not given a chance. No chance was given to prove myself. Of course, for this immediately the Supreme Court retorted, stating that, Madam, it depends on the kind and magnitude of the mistakes. Normally, if you do some mistake, some typographical error, yes, accepted. But if you suppose if you impose certain penalty, because in the entire IPC or CRPC the penalty is not mentioned, the judge can impose any amount of penalty. So if penalty is imposed unintendedly, we can understand. But you are a district judge, going to become a district judge in a few days, and you are authorized to give even a death sentence. So you on that cadre, you should not do such things. And the defense put by her is, a district judge, as a judge cannot be subjected to disciplinary proceedings for passing a wrong judicial order. Time and again we have been telling you, if there is any judicial wrong order, normally you have got a chance only to appeal, that's all. You cannot interfere with that. But here it is an alteration. That's why they have taken very serious view. Right, so why all these things happened are because of the prosecutor. The prosecutor requested more enhancement of the when she announced that 5 years punishment, he requested no, it should be more. Then she altered the section to 304 part 1. Anyway, the mistake has crippled, and of course we don't know whether she has done it intentionally or not. But since when she has got no review power, how can she alter the section of law into 304 part 1? This is the major flaw in her judgment. So anyway, it was taken a very serious view and she was dismissed from service. Now even the Supreme Court also did not interfere. She can't do anything. Of course, she can practice an advocate. Of course, let us hope, let us wish her all success in her future endeavors, as stated by our Honorable Judge U.S. Valley. Thank you very much.